Welcome to Lecture 7. For a start, when we had our lecture yesterday, at the very last session, I didn't press this video button on. So that meant that although yesterday's lecture was recorded, the last session, there was no picture of me in it. Now, I didn't know that. So if it happens in future, if you can't hear me or you can't see me, just type into the chat so I know. Because I can't see any of you and I can't even see me. So I don't know whether I have the video clicked or not. I think I have, but the only time I didn't was the very last session yesterday. So if it happens again, please just let me know you can't see me or you can't hear me. Now, there's a question already on the chat thing. It's asking about remedies under the 1982 Act. It seems to think that it's very different to the Sale of Goods Act. Well, the answer is, it's not that different, is it? Because under the Sale of Goods Act, I said I deal with remedies in a pack of 5. Now, in those 5 things, the first thing we talk about is damages. Then we talk about consequential loss. Then we talk about mitigation. Then we talk about non-pecuniary loss. And then we talk about it's the type of loss that determines recoverability and not the amount. The only difference between the two, sale of goods and supply of goods, is the first one, damages. That's because under the Sale of Goods Act, the Sale of Goods Act tells us how much in terms of damages. It talks about it under Section 51, damages for non-delivery. It then talks about damages for breach of warranty of quality. That's Section 53. So the only difference between 51 and 53 is 51, you have the right to reject. 53, unfortunately, you've lost your right to reject. But either way, you get damages. Now, under the Supply of Goods and Services Act 1982, there is no provision for the amount of damages. So if there is no provision under the statute, the only thing you do is you look at the common law. So common law damages, of course, as you know, is Hadley against Baxendale. Whatever arises naturally from the loss. So, of course, courts always have had a discretion. You know Hadley and Baxendale. I've seen your contract law notes. I've seen that you've covered all of those things in remedies. So you've covered pecuniary losses, you've covered distress losses, you've covered mitigation rules, you've covered all of that. So I'm merely reminding you of those things now. Now, we will have a little bit more later on in the syllabus anyway about remedies, but essentially numbers 2, 3, 4, and 5 are virtually the same. Okay, I suppose number 2, consequential losses, again, the Sale of Goods Act does provide for that under Section 54. But the consequential losses they talk about is no more than the common law remedy anyway, which you already studied at contract law. So effectively, the damages remedies for 79 and 82, virtually the same. The only difference is you have a section number attached to damages, no section number attached to 1982. Okay, well, I hope that answers the queries. Now, there are 4 major areas of the Sale of Goods Act we do need to look at. Passing of property and risk, we've done. Nemo dat, we've done. The implied terms under the Sale of Goods Act and the 1982 Act, we've done. But it does also include exclusion clauses. So let's revise exclusion clauses. Now, note Section 55 of the Sale of Goods Act. Section 55 allows parties to vary the implied terms under the Sale of Goods Act. This supports the fundamental principle of contract law, freedom of parties to contract. But Section 55 is subject to UCTA, Unfair Contract Terms Act. So the seller cannot vary Section 12 UCTA, but he can vary Sections 13, 14, and 15 of the Sale of Goods Act if it is reasonable to do so. Now, let's revise exemption clauses. Now, you did all of this in contract law. You are very, very lucky, because exemption clauses are also in your commercial law syllabus and it is examined. So not only did you get the marks when you answered questions on exemption clauses in contract law, you will get marks for answering the exemption clause question in commercial law. How lucky are you? I suggest You dig out your contract law notes on exemption clauses, because what I say will be very familiar to you. I'm only going to cover exemption clauses fairly briefly because we have so much new stuff we need to cover, and you've already done exemption clauses. You know, of course, there are two sets of rules. There are common law rules and there are statutory rules. We'll start off with the common law rules. This does not matter. It does not matter whether you've got a B2B or B2C contract. The common law requirements must be satisfied. The common law requirements apply to all terms of the contract, not just exemption clauses. The two common law requirements are incorporation and construction. Let's look at the first one, incorporation. The easiest way to incorporate an exemption clause is to put it in a written document and get the other party to sign it. Commercial contracts are often in writing, so yes, the terms and conditions, the T's and C's, will invariably be incorporated. This is true even if the buyer has not read those clauses. You know the case of Lestrange against Graucom. The cigarette vending machine case. Although the owner of the cafe didn't read the T's and C's, which contained the exemption clauses, she signed the document. The court held, yes, those T's and C's were incorporated into her contract. But of course, the signature must not be obtained by unconscionable means or by misrep. The case is Curtis against chemical cleaning. Mrs. Curtis took her white satin wedding dress to the cleaning company. She was asked to sign a document which the shop assistant said, oh, that's just excluding liability for damage to beads and sequins. In fact, the exclusion clause was excluding liability to any damage. The dress, of course, was damaged. The court said the shop cannot rely on the clause because the assistant's representation was false. Mrs. Curtis assumed that she would take the risk of damage to beads and sequins only, not to all damage. If there is no written contract, how does the seller incorporate an exemption clause? Well, the seller must take reasonable steps to bring the T's and C's to the buyer's attention at the time of the contract. Remember the case of Ollie against Marlborough Court Hotel? Mrs. Ollie checked in at the reception desk at the hotel. When she went to her room and shut the door, the back of the door had a notice to say that the hotel was not liable for customers' property left in the room. Mrs. Ollie left her fur coat in her room. When she came back, it had been stolen. The hotel said, hey, we've exempted liability. The court held that the exemption clause came too late. The contract was already made at the reception desk, so the clause at the back of the room door came too late. Now, commercial contracts often involve buyers and sellers in the same trade, and they often deal with each other, of course, so there might have been previous course of dealings. Hollier against Rambler Motors, the court said, taking a car for a service 3 or 4 times over a 5-year period, that was not sufficiently regular. So it needs to be more than that before a clause can be incorporated. So in Mrs. Ollie's case, for instance, if she stayed at the same hotel 3 times a week for 6 months, well, for sure, the first time she goes and stays in the hotel, the clause at the back of her bedroom door would not be incorporated. Maybe not the second time, maybe not the third time, but at some stage, if she stays in the same hotel 3 times a week for 6 months, at some stage, she will be deemed to have been given reasonable notice of that clause. See also the commercial case of Hillis against Arcos. This case concerned a contract for timber of fair specification. Timber prices were going up, so the seller did not want to sell. So the seller said, hey, timber of fair specification. Oh, that's just too vague. So it's not an enforceable contract. Court said, no, it's not too vague. It was an enforceable contract because the parties had dealt with each other many times before. So both parties knew what was meant by timber of fair specification. Now, T's and C's, terms and conditions, can be incorporated if the parties deal in the same trade. Important case of British crane hire against Ipswich plant hire. Both parties were in the business of hiring earth-moving equipment. One of them had a very big contract, but they were short of a crane, so they hired one from a competitor. Only after delivery of the crane did the competitor send the standard printed form, which said, if the crane breaks down or damaged, even if it's not your fault, the hirer must pay for that damage. Sure enough, the crane was damaged. The hirer said the T's and C's were not incorporated into the contract because the paperwork was sent after the contract was made, after delivery. The court said T's and C's were incorporated. Both parties were in the same trade and it was a standard term. So yes, it was an implied term in the contract. Having said that, T's and C's need to be incorporated in some kind of contractual document. Chappleton against Barry UDC. A chap in this case went to the seaside and he paid sixpence to hire a deck chair. He was given a receipt. At the back of the receipt, it said that the council were not liable for anything. If you're injured, we're not liable. If you die, we're not liable, etc. That sort of clause. The court said that the exemption clause was not valid because the receipt was a mere receipt. Because when a person goes to the seaside and you pay sixpence to hire a deck chair, you expect the receipt to be merely proof of hire, proof that you've paid the sixpence. You did not expect the receipt to be a full-blown contractual document. Of course, you have to be careful, because it does not mean that tickets cannot have an exclusion clause. If a reasonable person would expect some terms, it's okay if the face of the document says so. So, for instance, in the case of Parker against South East Railway, a woman went to the left luggage department of a railway station. She was given a ticket when she left her luggage. And the front of the ticket, it said, see back, see back. In other words, turn around and see back. Well, she didn't turn it and see back. But if she did, she would have seen at the back of the ticket, it said maximum liability £10. So, of course, the question for the court was were those terms incorporated into her contract? The answer was yes, incorporated. Because a reasonable person going to a railway station, leaving the luggage with the left luggage people, you would expect there to be some types of terms, some T's and C's. So if they tell you to see back, it's up to you whether you look back or not. In fact, it's even okay if the exemption clause is in another document altogether, as long as the ticket refers to it clearly. The case is Thompson against LMS Railway. A chap goes to a railway office and he wants to buy a ticket. On the ticket, it said there are T's and C's, and you will find you could either write to our head office for a copy of the T's and C's, or they are somewhere in the railway station. In actual fact, Mr. Thompson was almost illiterate. He couldn't read and write. And there were clauses in the railway station. There were 500 T's and C's, 500 clauses. Question for the court was, were those clauses incorporated in his contract? The court said, yes, incorporated. So clearly, as long as the ticket refers you to where those clauses are, it's up to you whether you read them or not. And of course, Mr. Thompson himself was virtually illiterate, but the court said, no, it's an objective test. So as long as it is reasonable, bring it to the attention reasonably to a normal person, that's enough. Bear in mind, however, the more unusual or the more onerous the clause, special measures must be taken to bring that clause to the other party's attention. Interphoto Picture Library against Stiletto. This case, Interphoto Picture Library, this case is not actually on exemption clauses, but it's the same principle, and it's the one that is usually used to support the proposition. I mean, essentially, the court said that the clause was not enforceable because it was very unusual and onerous. The photo library had to do more to bring that clause to the attention of the agency. In fact, in Sperling against Bradshaw, Denning said he had seen some exclusion clauses which were so unusual and so onerous that the clause would have to be printed in red ink on the face of the document with red hand pointing to it before he would hold reasonable notice was given. So the first common law rule is incorporation. The idea being, unless the exemption clause is incorporated into the contract, there is no need to discuss its validity. So, of course, exam technique will tell you that, yes, the seller's T's and C's will be incorporated. Only then you go on to discuss the second common law rule, which is construction. Does the clause cover the liability that has arisen? Now, the words used must clearly cover what they are intended to cover. If there is any doubt as to its meaning, the courts will construe the clause in the other party's favour. That's the contra proferentem rule. In other words, the courts will construe the clause against contra proferentem, the party proffering that clause, that party trying to rely on that clause. Andrews against Singer is a standard case. This case involved a contract to buy new Singer cars. One car was a used car. The Court of Appeal said the term new Singer cars was an express term of the contract. So the exemption clause did not help the seller because the seller's exemption clause was only trying to exclude implied terms, whereas new was an express term. Again, a good case is Houghton against Trafalgar Insurance. An insurance company excluded liability if the car was carrying an excess load. The driver had given 6 people a lift in a 5-seater car. Load was interpreted to mean excess baggage. It does not apply to a car carrying too many passengers. So the insurance company was liable. The clause did not exclude liability. Now, the rationale for the contra proferentem rule is that a party has very valuable rights under a contract. So it must be very clear that a party intended to give up those rights. So the clause must be clear and cover the particular loss or breach of contract. Let me tell you about Andrew Green against Betfred. This case involved a gambler. He played blackjack on Betfred's mobile app for 5 hours non-stop. His winnings came to £1.7 million. Betfred refused to pay out. They said, there was a glitch and the game had malfunctioned. See, what happened was, the longer the game was played without stopping, the chances of getting winning cards increased to such an extent that eventually the player would only get winning cards. You see, Betfred was relying on an exclusion clause in their T's and C's, which said that Betfred did not have to pay out if there was a malfunction of software. The court said the gambler was entitled to his £1.7 million winnings. Betfred must pay. The court said two things. Firstly, the exclusion clause was not incorporated into the contract because they were not brought to the gambler's attention sufficiently. The T's and C's were in the usual checkbox. This was all done online via the app. So the T's and C's were in the usual checkbox with a text next to it saying, I accept Betfred's T's and C's. You know what it's like when you're trying to buy something. There's a box that you have to click to say you agree to the T's and C's. Otherwise, you can't get to the payment page. Anyway, it's the same thing here. The T's and C's was in this little checkbox with a text next to it stating, I accept Betfred's T's and C's. Now, if you had printed it out, it would have come, in this case, to 24 pages. The court said the terms were so closely typed in lowercase, or it was all in uppercase. The court said it's very difficult to read. So even if this gambler printed it out, it was difficult to read anyway. What was interesting is that the judge said these click-wrap acceptances, that's what we call them, click-wrap acceptances of T's and C's, they can be incorporated. But in the context of a gambling contract, a gambler is unlikely to spend loads of time sprawling through the T's and C's, especially if it's repetitive and did not appear to be relevant to him. So in this case, the court said the T's and C's were not incorporated anyway. The second thing the court said was that the clause was not clear as to its meaning. I mean, the word malfunction was not defined. So the court said, aha, contra proferentem. So the clause, even if it was incorporated, did not cover the situation where the game functioned fine, but which produced a set of odds that Betfred had not intended. Now, we haven't done the CRA unfair terms yet. We will, but just note for now that the court also said that the terms were not transparent nor fair. Not transparent because the terms need to be clear and legible. Judge said closely typed lowercase or all caps, that's not legible, not fair. Now, as I say, we'll be studying CRA and unfair terms later on, but just note it here for now with this case, Andrew Green. Let's look at the Maccini lady. This case concerned the sale of gas oil. The buyer said breach of section 14, unsatisfactory, unfit. The seller said they excluded for breach of section 14. Now, as you and I know, section 14 is a condition, but the exclusion clause did not actually use the words conditions. The contract excluded warranties or misreps, but not condition. So the question for the court was, did the exclusion clause exclude for section 14? The Court of Appeal said no, contra proferentem. So the Court of Appeal took a very hard approach, and contra proferentem rule was strictly applied. You don't exclude for condition. The breach was a breach of a condition. Compare the Maccini lady with Air Transworld against Bombardier. The buyer bought a private jet. He claimed breach of sections 13 and 14, description, quality and fitness. The contract included an exclusion clause, which I've set out in your handout. Read that in your own time. It's a massive clause. The clause was essentially excluding for everything, including satisfactory, quality and fitness for purpose. The clause was clearly meant to exclude the Sale of Goods Act, but the clause did not actually use the word conditions. So the buyer argued, aha, this is the same situation as Macini Lady. Macini Lady didn't use the word condition, and the court said seller loses out. So in Air Transworld, the buyer said seller should lose out too, because they did not use the word condition. So the seller did not exclude for sections 13 and 14, which are conditions. The court said, yes, the clause did exclude the Sale of Goods Act conditions. The court said, although the seller did not use the word conditions, the clause was sufficiently clear to exclude the Sale of Goods Act conditions. There was no ambiguity, the court said. There was only one meaning. Wording the exclusion clause, essentially it was excluding every obligation possible implied by law. It was what the parties agreed. So yes, it does cover the Sale of Goods Act conditions. How do we reconcile this case with Macini Lady? Well, one fundamental principle in commercial contracts is party autonomy. You agree what you want to agree, and the courts will enforce your contract. In Air Transworld, the exclusion clause was essentially saying that the seller and the buyer's rights and obligations were found exclusively in the contract. The clause made it very clear that the seller and buyer had no other rights and obligations of any kind. There was no ambiguity. So the Sale of Goods Act conditions were excluded. But just be a little bit careful with Air Transworld. It's a little special. Although the judge said no need to use the word conditions, it invariably depends on the facts of each case. What about negligence? Well, courts are very, very reluctant to allow exclusion of negligent liability. So if a party wants to exclude for negligent liability, he must do so specifically. In Hollier against Rambler Motors, the clause excluded liability for damage caused by fire to cars on premises. Now, the fire was caused by the negligence of the car dealer. The Court of Appeal said the clause was not clear if it covered fires caused by negligence. So the court said the clause did not cover the loss. It was not enforceable. As I say, courts are very reluctant to allow exclusion of negligent liability. So the wording of the exclusion clause must be very clear to show that the parties intended to exclude that liability. Now, the Privy Council in Canada Steamship against the King used to be the leading case on this, but it has recently been suggested that the Canada Steamship test has limited application in commercial contracts where parties are of equal bargaining strength. We'll see this in a minute. No need to go into the detail of Canada Steamship, just mention the name. So if you want to exclude negligence, it is best to use the word negligence. I mean, having said that, it doesn't actually have to be the word negligence. A synonym is okay. So words like neglect will cover negligence. This was confirmed in Monarch Airlines against London Luton Airport. We don't need to know the facts of Triple Point against PTT. Lady Justice Arden said, negligence should be given its ordinary meaning. Negligence relates to both the tort of negligence as well as the negligent contractual liability to use reasonable care and skill. Now, Triple Point is a Supreme Court case. It also confirms that very clear words are necessary before the court will conclude that a contract has taken away valuable rights or remedies. The assumption is that the parties will not give up valuable rights. Okay, let's move on a little bit. We're looking at exemption clauses and how they are interpreted. Although the common law rule is contra proferentem, note that in B2B contracts, where parties are of equal bargaining strength, courts might not interfere. Courts seem to be moving away from the contra proferentem rule in B2B contracts, whereas, as I say, parties are of equal bargaining strength. See the case of Persimmon Homes against Uvar. The developer employed consultants to do a report on asbestos. The consultant said there was no asbestos on the land. Now, the consultant's T's and C's included a clause which excluded liability for any claim in relation to asbestos. Of course, there was asbestos on the land. The developer was now suing the consultants. The consultant said, hey, we excluded liability. The Court of Appeal said, yes, the consultants had excluded liability. The court said the consultants can rely on their exclusion clause. Although the clause did not use the word negligence or a synonym, the clause was wide enough to exclude negligent liability. The parties intended to exclude all liability relating to asbestos. This included negligent liability. What about fraud? I mean, can you exclude for your own fraud? The answer is no. Courts don't like parties excluding for negligent liability as it is. Fraud, by definition, involves dishonesty. Courts won't allow a party to exclude liability for fraud. It would be against public policy. Now, fundamental breach. Now, you will know the case from contract law. Photo production against Securicor. Securicor was to provide a night watchman, a patrol service. One night, the Securicor employee in the factory was on duty. He lit a small fire. He did so deliberately, but he didn't mean to destroy the factory. Actually, the factory completely burnt down. The contract contained an exemption clause that said Securicor were not liable for the acts of their employees. The House of Lords said this clause was enforceable, even though there was a fundamental breach of contract. The court said there was no rule of law that a fundamental breach of contract meant that the exemption clause was automatically unenforceable. You must construe the clause in the usual way to see if it covers the damage in question. Of course, in this case, as you know, the factory owner was paying very little for security service. The court said, well, freedom of the parties to contract. So the factory agreed to the exclusion clause that obviously it's more likely to be allowable. Anyway, the court took into consideration that both parties had insurance. So the court said it was okay for the clause to be enforceable, even though there was a breach of contract. So it just depends on whether the exclusion clause covered the breach. Certainly true for commercial contracts. Now, those are the common law rules in corporation construction. Now let's look at the statutory regulation of exemption clauses. We're looking at B2B contracts. So Unfair Contract Terms Act regulates B2B exemption clauses. UCTA cannot be excluded by express agreement. You know all of this already. I'll briefly run through the most important section numbers. Section 2 sub 1 says, the seller cannot exclude liability for death or personal injuries. Such a clause is void. Now, to sue, of course, the injured party must establish negligence. In other words, breach of the obligation to take reasonable care for the safety. So if a person's iPhone blows up in the shop and is injured by their own iPhone, then the shop is not liable. The shop is only liable for negligent liability. So for instance, if the floors are wet and it causes the customer to slip, yes, that's when the shop cannot exclude their negligent liability. Section 2 sub 2 applies to other loss, in other words, damage to goods like clothing. A supplier can exclude negligent liability if it is reasonable to do so. We will look at what is reasonable later on. Now, whether the claim falls within section 2.1 or 2.2, that depends on the nature of the injury caused by the negligence, not the particular loss for which the claim is made. Example: financial loss on death or personal injuries is a claim under section 2 sub 1. So the seller cannot exclude or restrict liability. It's void. So if I fall because of the wet floor in the shop and I am in hospital for 6 months and I can't work, the shop cannot exclude liability because that loss, that claim, falls under section 2 sub 1. Section 3 says UCTA applies to standard business terms. So any term not covered by a specific section number under UCTA must be subject to reasonableness. Now, section 6 is very important indeed. Section 6 says the seller cannot exclude for breach of section 12 of the Sale of Goods Act. You tell me, what is section 12 of the Sale of Goods Act? You tell me. Because seller can never exclude for breach of section 12. Thank you very much indeed. Correct. The answer is title. So section 6 says the seller can never exclude for breach of title. It's strict liability, as we said. Section 6 goes on to say the seller can exclude for breach of sections 13, 14, and 15 of the Sale of Goods Act if it is reasonable to do so under Schedule 2. Okay, so my question is, what is section 13 of the Sale of Goods Act? What's section 13 of the Sale of Goods Act? Thank you, correct. Description. What about section 14? 14 of the Sale of Goods Act. What's that? Section 14.2 and 14.3. What's that about? Sale of Goods Act. Thank you very much. Correct. Quality and fitness for purpose. And section 15, of course, is to do with sample. So what section 6 UCTA is saying is that the seller can only exclude for description, satisfactory quality, fitness, and sample only if it is reasonable for him to do so, to exclude. Now, when we looked at software, do you remember it was almost the first lecture? It seems a long time ago. But when we looked at software, we said software is not goods. So the buyer does not get the protection of section 6 UCTA. Only section 3, the protection. All terms must be reasonable. Whereas you see, if section 6 applies, the seller can exclude for 13, 14, and 15 only if it is reasonable to do so. So a greater level of protection. Section 7, unfair contract terms, like section 7 UCTA says exactly the same thing as section 6, but in relation to the Supply of Goods and Services Act 1982. So the supplier cannot exclude for title, section 2, but as far as description, quality, and fitness is concerned, 3 and 4 of the 1982 Act, the supplier can exclude only if it is reasonable to do so. Now, what do we mean a term must be reasonable anyway? Well, this is defined in section 11. Section 11 says whether a clause is a fair and reasonable one is to be judged in accordance with the circumstances known or ought to have been known when the contract is made. The burden of proof is on the party trying to say the term is a reasonable one. In other words, it's normally the seller who wants to show that the term is reasonable. Section 13, UCTA, applies to all restrictive type clauses. So section 13 is saying it doesn't matter what you call your clause, if it is restrictive in some way, then UCTA will apply. Example, supposing the clause says, you must tell me about the breach within 2 hours, otherwise I'm not liable. Well, the authority for that is the House of Lords case of Smith against Bush. We'll talk about that case a bit later on anyway. Now, Schedule 2, of course, gives us the guidelines as to what is meant by reasonable. Technically, just note that technically, Schedule 2 only applies to sections 6 and 7 of UCTA. But the courts have applied the test of reasonableness to other situations. For instance, to section 3. Section 3 UCTA says all standard business terms must be reasonable. But as I say, technically, Schedule 2 only applies to sections 6 and 7. But the courts seem to apply it to everything anyway under UCTA. Schedule 2 guidelines include the relative strength of the parties' bargaining positions. So if the parties are kind of equal, then probably the court will say, yeah, that clause is reasonable. Whether the buyer received an inducement to agree to the exclusion clause, whether the buyer knew or ought reasonably to have known that the clause existed. Now, in the case of a term excluding liability, if a condition is not complied with, what was the likelihood of compliance? I mean, for instance, if the hotel had told Mrs. Ollie that unless she puts her valuables in the room safe, the hotel will not be liable. Well, how can Mrs. Ollie stick her fur coat in the room safe? That's just crazy, right? That clause would be unreasonable. Or whether goods are manufactured or processed or adapted to a special order of the buyer. So, for instance, is it a one-off machine, one-off special industrial machine? If it's very tricky to make, maybe it's reasonable for the seller to put in an exemption clause. And of course, the allocation of risk affected by the clause. I mean, did the parties allocate risk? What about professional advice? Can a supplier exclude? Well, the case is Smith against Bush. A surveyor was negligent. He valued the property higher than he should have done. He called his exclusion clause a disclaimer. House of Lords said, yes, UCTA applied, because it doesn't matter what you call your clause. If you are trying to restrict your liability in any way, UCTA applied. Lord Griffiths, in the House of Lords, he reiterated Schedule 2 guidelines. He said, as far as professional advice is concerned, there are further considerations to be taken into account as to whether an exclusion clause is reasonable. Firstly, he said, was it reasonable to get advice from an alternative source, taking into account of costs and time? I mean, in Smith against Bush itself, the house was a very low price one. So it was less reasonable to expect the buyer to pay for a second opinion. Secondly, was the task undertaken a difficult one so that an exclusion clause was necessary? I mean, the idea is the more difficult the task, the more reasonable it is to try and exclude. I mean, if a surveyor was asked to value, let's say, under the Hong Kong Convention Center, then it might be reasonable for him to put in an exemption clause in some way. It's a particularly difficult task. Thirdly, was it reasonable for the surveyor to insure? Well, certainly more easy than for a buyer. On the facts of Smith against Bush, the House of Lords said the exemption clause was not a reasonable exemption clause. Now, we know Schedule 2 gives us guidelines, but what do the cases tell us? Well, if the clause is in common use and well known in the trade, prima facie, it is more likely to be reasonable in accordance to Schedule 2 guidelines. The case authority is Overseas Medical Supplies against Orient Transport. The facts of the case don't matter. But even if the clause is an industry standard, if it is well known that no one in the trade actually relies in practice, it will not be regarded as reasonable. George Mitchell against Finney Lock Seeds, an important House of Lords case. Contract was for cabbage seed. The cost was £200. The seed was not cabbage, but it was something else. This caused the farmer £60,000 worth of loss. The contract limited the seller's liability to the price of the seed. In other words, £200. The House of Lords said this was unreasonable for 3 reasons, the court said. First of all, the wrong seed was due to the seller's negligence. Secondly, the seller could have insured without increasing the price of the seed very much. Thirdly, the court said it was not usual for anyone to rely on the clause in the trade anyway. You see, the modern approach to whether an exclusion clause is reasonable or not is to see if it attempts to leave a customer without a remedy for a serious breach of contract. If the customer has no remedy, then the court is likely to say that the clause is unreasonable. If the clause gives the customer some remedy rather than no remedy, then it has a better chance of being found reasonable. See the case of Aurora Fine Arts against Christie. The buyer bought a painting from auctioneers. The painting turned out to be a forgery. The auctioneer's T's and C's had a clause which limited a buyer's claim to a full refund, but no compensation under any circumstances. The court said, yes, the T's and C's were reasonable. The buyer did get a refund after all. And the court did take into account that the buyer in this case was a very rich Russian man, and he had dealt with the auctioneers many times. So he was of equal bargaining strength with the auctioneers. Then, of course, we have other important cases, which include St. Albans against International Computers. Now, we saw this case when we asked whether computer software was goods. The Court of Appeal said the computer software was not goods. Nevertheless, this does not mean the local authority didn't have a cause of action against the software company. Of course they do, because the courts will imply a term into the contract to say that the software must be reasonably fit for purpose. We said that the courts will use the business efficacy test and the officious bystander test. St. Albans, in this case, sued for 2 amounts. St. Albans, the local authority, sued firstly for £484,000 lost in the local poll tax, which the community should have paid. Second thing they claimed was that they had to pay £685,000 fine to central government. The clause in the contract limited the software developer's liability to £100,000. The Court of Appeal said, first of all, £484,000 claimed was not recoverable because the community still owed that amount. The local authority just has to invoice the local community and they still have to pay. Second thing the court said, limiting liability to £100,000 was not reasonable. So St. Albans was entitled to claim £685,000, which was the fine that they had to pay to central government. Compare St. Albans with Watford Electronics against Sanderson. Watford here sold personal computers by mail order. They bought a one-off software program from the seller for integrated accounts, stock control system, purchase order, budgets, that sort of stuff. They paid £105,000. The software did not work properly. Watford Electronics sued for breach of contract and loss, which, including the loss of profit, time and effort trying to make it work came to £5.5 million. The contract clause limited the software's developer's liability to the contract price of £105,000. The Court of Appeal said it was a reasonable limitation clause because both parties were large and they were experienced companies, and the parties had negotiated terms of the contract. It was not a standard business term. The emphasis these days is whether the parties are at equal bargaining strength. So if the answer is yes, then probably the clause is reasonable. We said we'd come back to this case, Balmoral against Borealis. Buyer, if you remember, claimed that the Borisine they bought was not satisfactory nor fit. On the facts of the case, there was no breach because the defect was due to the buyer's own incorrect manufacturing process. The judge went on to discuss exemption clauses. The seller had an enormous exemption clause. It essentially excluded all liability if the seller was in breach. The exclusion clause placed the entire risk of failure on the buyer. This, the court said, was not reasonable. The judge recognized that in the real commercial world, parties regularly agree in advance who bears the risk. For instance, the case we already looked at, Watford Electronics against Sanderson, parties had allocated risk. There were serious negotiations between the parties' lawyers before the contract was finalized. This is very different to the Balmoral case, when the contract terms were more or less take it or leave it. Now, excluding liability for consequential loss. Now, most commercial contracts will include an exemption clause. More often than not, the seller is trying to exclude liability for consequential loss. Now, of course, clients don't ever want to think about it when you enter into a contract because no one thinks anything will go wrong. But it is very important to think about it. So when the seller tries to exclude liability for consequential loss, what does consequential loss mean? Remember, Hadley against Baxendale, the common law rule has two limbs to it. Limb 1 is direct loss. The injured party can claim for loss, which flows naturally. It's normal loss. Limb 2 is indirect or consequential loss. This is the loss which an innocent party can claim because although it arises outside the usual course of things, the party in breach had advance information of special circumstances. The classic case to illustrate the two limbs is Victoria Laundry against Newman. We know this case. I won't bother reminding you this case. You know it from your contract law. So when a clause excludes for consequential loss, what financial loss is the seller trying to exclude? Well, in the past, if the contract clause tries to exclude for consequential loss, courts usually interpret this to mean excluding limb 2 losses. The trend, however, is that courts are interpreting consequential loss more widely. It could cover all financial loss. The case authority is the Star Polaris. The facts don't matter at all. In the past, if parties try to exempt liability, courts will construe the clause very narrowly, and they were just trying to achieve a balanced or fair result. But the modern approach is this. If the parties are sophisticated and they negotiate their commercial contract, courts will give a wider meaning. Now, if parties agreed to exclude for all financial loss, then so be it. Courts will enforce. Party autonomy wins. Okay, that covers exemption clauses. Please bear in mind that I have only summarized everything. You need to dig out your contract law notes to remind yourselves of the detail. I can tell you that exemption clauses comes up in commercial exams, sometimes as problem questions, sometimes as essay questions. I was hoping that we would have time to look at a typical exemption clause question, but we don't have the time. Anyway, as I said, as you've already done exemption clauses in contract law, you will already have had some practice on that. Let's move on. There are 4 major areas of the Sale of Goods Act. Passing of property and risk, we've done. Memo Dat, we've done. Implied terms and exclusion clauses, we've done that. The final topic is ROT, retention of title clauses. So I think what we'll do now is we'll take a 10-minute break, and when we come back, we will cover ROT clauses. All right, we'll take a 10-minute break. Okay, so let's look at retention of title clauses, ROT clauses. Now, we've looked at when property is transferred and when risk passes. When does property pass? Well, the starting point is section 17. It depends on the intention of the parties. Now, this is true for specific goods, but even with unascertained goods, once they have become ascertained, we still go back to section 17 anyway. Only if the intention is not clear, then we look at section 18 rules 1, 2, 3, 4, and 5. Section 18 rules suppose that the intention of the parties is not clear. We did all of this in lecture 1. The situation we are looking at now is where the seller wants to make it very clear. Seller sells goods to the buyer and he delivers goods to the buyer, but he wants to make sure that property does not pass to the buyer until he has been paid. Seller wants to add a clause in the contract to say this. Can he do this? Of course. Section 19 says, if the seller reserves his right of disposal, in other words, where he reserves property, till certain conditions are fulfilled, property does not pass until those conditions are fulfilled. Well, you might think, well, better not to retain title in goods, because if property passes to the buyer, then the buyer has risk, because section 20, someone says that. So if goods are damaged or stolen, then it's the buyer's loss, and the buyer must still pay the seller. But you see, the other side of the coin is that if the buyer has property in goods and the buyer sells the goods to a third party, the opposite of nemo dat, the third party can get good title. Because if you have title, you can give title. It's the opposite of nemo dat. So if the buyer absconds or he goes bust without paying you, the seller, loses out. So it depends really on the seller's type of business. I mean, usually a seller is more concerned with a business buyer going bust rather than a business buyer being fraudulent and selling goods to a third party. If a buyer goes bust, the seller, of course, has no chance of his invoice being paid. He will be an unsecured creditor like everyone else. And preferential creditors, floating charge holders, all these people take precedence. But if the seller retains property in goods under section 19, maybe the seller has rights in the goods themselves, so he can recover those goods. Forget the invoice, at least get the goods back. That's why the seller wants to keep property in goods until he gets paid. At least the seller gets the goods back if the buyer goes bust. Under Section 19, he can do this. Note, if there is no express agreement in the contract about when property is to pass, then property passes under the Section 18 rules. So is it a matter of the seller putting a term in the contract to say property is not to pass until he gets paid? Well, the answer is yes. It's normally very straightforward. I sell you this piano on conditional sale. You pay me £1,000 per month for 12 months. This is conditional sale. I reserve title because property is with me until you have paid all 12 installments. But it's not always so straightforward, because in the real world, when a business seller sells to a business buyer, the seller knows that the buyer is likely to sell the goods to someone else. Only when the buyer gets paid can he then pay his seller. So the seller has to allow the buyer to resell the goods before the buyer gets property. So how can we resolve this? Well, we will look at the leading case in just a minute. Note one very important thing. The general law will not imply an ROT clause into a trading relationship in the same way that there are implied terms of satisfactory quality and fitness for purpose. You see, with the Sale of Goods Act, as soon as you have a contract for the sale of goods which satisfies Section 2 sub 1, the law automatically says the Sale of Goods Act terms are implied into your contract and you cannot contract out. Very different with ROT. If the seller wants to reserve legal title to his goods, he must expressly say so. Remember the common law incorporation rules. We've just reminded ourselves of that. If the ROT clause is on a delivery note or on the invoice, it's probably too late, because it would be incorporated only after the contract was made. Of course, it is subject to previous course of dealings. So we know the case of British Crane Hire against Ipswich Plant Hire, and we talked about Ollie against Marlborough Court. So the common law incorporation rules, which we've just revised, they apply to any term of the contract, not just exemption clauses. So it certainly includes ROT clauses. Now, the simplest examples of ROT clause is in your handout. Legal title to the goods shall not pass to the buyer unless the seller has been paid in full, or title to the goods that are the subject of this invoice will not pass to the purchaser until payment in full for such goods have been received by the vendor. Now, in practice, of course, the ROT clauses are much more detailed. Of course, not every seller wants an ROT clause anyway. I mean, example, let's say I make sandwiches and I supply the corner shops to sell to their customers. I do not want to reserve title under Section 19, because if the shop goes bust and does not pay me, I don't want my sandwiches back. Well, let's look at the leading case, aluminium industry against Romalpa. The seller in this case was a Dutch company called AIV. The buyer was an English company called Romalpa. The contract was for aluminium foil, which the buyer used in a manufacturing process. This process involved mixing the foil with other substances to make the finished product. The seller and the buyer dealt with each other lots of times. The buyer went bust. At that time, the buyer owed the seller £122,000. The buyer still had £50,000 worth of aluminium foil, and in a separate bank account, they had £35,000 which was the proceeds of sale of the finished product sold to the sub-buyers. In essence, clause 13 of the contract said three things. Firstly, it said ownership of the unmixed foil remained with the seller till he got paid. Secondly, ownership of the mixed foil would transfer to the ownership of the finished product until the seller got paid. Third thing, the buyer was to keep the finished goods as fiduciary for the seller. The clause allowed the buyer to sell the foil and the finished goods as the seller's agent, but the buyer was to keep the sales monies in a separate account for the benefit of the seller. You see, the seller was now claiming ownership of the foil in the buyer's possession, as well as the amount in the bank account. The Court of Appeal held that the seller was entitled to recover £50,000 worth of foil and also the £35,000 in the separate bank account. The court said three things. First of all, they said the unmixed foil not yet sold still belonged to the seller because the seller had reserved title under Section 19. The second thing the court said was that the foil, whether it was mixed or unmixed, the foil sold by the buyer now belonged to whoever bought it because the seller expressly authorized the buyer to sell. Third thing, court said, the seller was entitled to the money in the separate bank account because the contract term imposed a fiduciary duty. The buyer acted as agents. The buyers were bailees of the foil. The seller can therefore trace into the proceeds of sale. Now, this was a unanimous decision of the Court of Appeal. At first instance, the judge sat alone. It was the first time ROT clauses came up. The judge held that no registrable charge arose, and this point was not discussed in the Court of Appeal. Romalpa is not a satisfactory decision. It was great for the seller in question, but as an authority, it is not satisfactory. I mean, the first thing the Court of Appeal said was that the unmixed foil still belonged to the seller. This bit of the decision is okay, because that's the whole point about Section 19. But as far as the second point is concerned, in other words, when the buyer sold the foil to a sub-buyer, the foil now belonged to the sub-buyer. Well, I suppose that bit of the Court of Appeal decision is also okay. But what the Court of Appeal went on to say about the buyer acting as fiduciaries, that is not okay. Point 3 of the Court of Appeal decision as it stands is basically saying that all the money received by the buyer from the resale of the goods, in other words, that money that was in the separate bank account, the court was saying all that money was held on trust for the seller, including any profit the buyer made from making and reselling the goods. So the amount of money is more than what the buyer owes the seller. The seller gets to keep the excess. It is highly unlikely that parties intend for this to be the situation, but effectively, this is the outcome of the Court of Appeal decision. I mean, all the seller wants to do is to protect himself in case the buyer goes bust. The seller only wants enough of the proceeds to pay off what the buyer owes him. But this arrangement is a mortgage or a charge. It's like me buying a flat. The bank lends me money and takes a mortgage or a charge over my flat. The bank only wants to secure what I borrowed. There was no intention for the bank to participate if the flat price goes up. The bank does not take a share of profits. But a mortgage or a charge needs to be registered under Section 859A of the Companies Act within 21 days. Otherwise, Section 859H says that the clause is void. But this point was not argued in the Court of Appeal. The first instance judge said no registrable charge arose, and the Court of Appeal did not discuss this point. So Romalpa is an unsatisfactory decision. Subsequent cases have, not surprisingly, restricted authority of the case. Now, the Romalpa buyer receivers, they asked for leave to appeal to the House of Lords, but this was refused. Presumably, the judges thought that this case was not of any real importance to anyone except the parties involved, but quite the opposite. Lots and lots of businesses started to insert ROT clauses in the contract. Romalpa, 1976 case. Romalpa happened just before Margaret Thatcher came into power. So there was loads of business activity. Let's look at these clauses more closely. Now, first of all, we need to look at unmixed goods. Now, this is sometimes called the simple clause. It is clear from the Romalpa case that where the seller puts a term in the contract reserving title till he gets paid, this is effective. This was confirmed by the Court of Appeal in Clough Mill against Martin. Always said the Romalpa was confirmed by Clough Mill, but there's no need for the facts at all. That's why, you see, Romalpa seller got back the £50,000 worth of foil. Now, we have no problems with this at all. It's straightforward Section 19. So if the seller retakes the goods, if the seller sells the goods elsewhere for the same price, okay, the seller suffers no loss. If what the seller gets is less than the invoice value, then the seller is an unsecured creditor for the balance. Now, in the real world, the seller and buyer will deal with each other lots of times. Maybe the seller supplies goods every month. Suppose the seller and the buyer have previous dealings, and the seller is owed an amount from a previous contract which has also not yet been paid in full. Can the seller add an ROT clause to include all sums due to the seller? The answer is yes. If the seller adds an all liabilities clause or an all monies clause. The authority for that is Armour against Thyssen. No need for facts. An example of an all monies clause, I've got it in your handout, is something like this. Legal title to the goods shall not pass to the buyer till all sums due on the seller's account have been paid. So essentially, title will not pass until all sums due have been paid. So as far as unmixed goods is concerned, Section 19 is no problems. And if the seller adds an all liabilities clause, the seller can retake goods to satisfy all of the buyer's debts. The question here on the screen is, so is it risky to cite Ramalpa in the exam? My goodness, no, because that's not true at all. Because if retention of title clauses comes up, 1,000% you must talk about Ramalpa, 1,000%. So for instance, you need to discuss what the clauses were in Ramalpa and what the Court of Appeal said about those clauses. And then you have to go on and criticize to say why Ramalpa is not a good decision. It was fine as far as unmixed goods are concerned, but as far as everything else the court was saying, it's a terrible decision. That's why all subsequent cases have actually sort of prevented the Ramalpa case decision coming back again. But you have to, 100%. So it's not a matter of risky talking about the Ramalpa case. You have to talk about the Ramalpa case. It's the key thing around an ROT question. All right? Okay. Well, note, for instance, the second thing the Court of Appeal in Ramalpa said. Look at the second thing the Court of Appeal said. They said the foil sold by the buyer belonged to whoever bought it. It is because the seller had expressly authorized the buyer to sell. Well, this is fine because there was an express term. But even if there is no express term, the courts will imply a term that the buyer can resell anyway. The case is 4 Point Garages against Carter. What happened here was a customer wanted to buy a Ford Escort from a dealer, wanted to buy a car from a dealer. The customer paid the dealer in full. The dealer bought the car from a seller who was another car dealer. Now, the seller and the buyer dealer had a contract with an ROT clause. ROT clause means until you pay me, I retain property. So there was that clause between the seller and the buyer. The buyer dealer went bust without paying the seller. The seller wanted to recover the car from the customer. Court said no. The seller was not entitled to the car. The ROT clause is not effective between two commercial car dealers. It was an implied term that the buyer was authorized to resell. It was an ordinary business deal. As we said, you see, if the buyer doesn't sell to a sub-buyer, how does the buyer get enough money to pay the seller? So we have to allow the business buyer to resell. Now, this case, 4 Point, has been followed in Fairfax against Capital Bank. What happened here was the buyer bought printing machines from a seller in China. He bought it under a finance company, under a finance agreement with finance company number 1. There was an ROT clause. The buyer sold to a sub-buyer who bought it under a finance company with finance company number 2. The deal was that finance company number 2 would buy and pay for the machines, and they would lease the machines to the sub-buyer. Finance company number 2 paid the buyer, but the buyer went bust before the buyer paid finance company number 1. Finance company number 1 claimed ownership. They sued finance company number 2 for conversion. You are wrongfully interfering with my goods because finance company number 2 had leased the machine to the sub-buyer. Court of Appeal said, finance company number 2 are not liable. The purpose of the transaction between the seller and the buyer was for the buyer to obtain goods for resale. It would be odd if the buyer then had no right to resell. The right to resell is implied. So you see, even if there is no express term that the buyer can resell, the court will imply that term anyway. So even a simple ROT clause is not a reliable method for the seller to ensure that payment is made before title passes, not when commercial parties are involved. Now, of course, this is also a nemo-dat situation. See, finance company number one finances the deal to the buyer, so finance company number one is the owner. But the buyer is a buyer in possession for Section 25 purposes. So if the buyer sells as if he were a mercantile agent, the bona fide purchaser gets good title. We know the case of Newtons of Wembley against Williams. The bona fide purchaser here is finance company number two. So you can see that first diagram, if I flatten it out, then it looks like our normal nemo-dat problem. Finance company number one, buyer, finance company number two. And buyer here is a buyer in possession, Section 25, which means finance company number two will get good title under the nemo-dat exception. Suppose another situation. Suppose the seller sells to a buyer with an ROT clause. The buyer resells to a sub-buyer also with an ROT clause. Does the sub-buyer get good title under Section 25 buyer in possession exception? The answer is no. That's because Section 25 only applies when the buyer sells to a third party. Only then he sells as if he were a mercantile agent in possession of the goods. But it is only a sale if the third party gets title. The ROT clause prevents that. Between the buyer and the third party, in other words, between the buyer and the sub-buyer, that is only an agreement to sell because of the retention of title clause. You don't have property because I've retained it. So the agreement between the buyer and the sub-buyer, it's only an agreement to sell. So property does not pass, not under Section 25. Now, although Section 9 of the Factors Act says the same thing, the wording of Section 9 is different in one material respect. Section 9 includes a situation where the buyer agrees to sell to a sub-buyer. In that case, the sub-buyer gets the nemo-dat protection, but only if you use the wider wording of Section 9 of the Factors Act. Even so, Section 25, Sale of Goods, Section 9, Factors Act, it refers to as if the buyer were a mercantile agent. It presupposes that the buyer is not actually a mercantile agent. Whereas in Romalpa cases, the buyer really is a mercantile agent in his buy and sell capacity. In that case, the nemo-dat exception is not Section 25 nor Section 9. Which exception is it? if you were asked to advise the sub-buyer, you're going to try and argue the nemo dat exception. What we're saying is, if the buyer really is a mercantile agent in his buy and sell capacity, which of the nemo dat exceptions would the sub-buyer try and argue? That's why he gets good title. That's what he's going to argue. Which of the nemo dat exceptions would the sub-buyer argue? You tell me. Every family should buy my very small house. You can do it by process of elimination, but there's only one that involves the buy and sell capacity. Not section 24. Section 24 is should buy, not section 24. Every family should buy, right? So every family should buy. Look, forget it. We've done nemo dat, but let me just not go through that before. The exception we're looking at is the factors exception. Section 21 sub 2. Section 21 sub 2. You see, what we're talking about here is if you have a situation between the seller and the buyer having an ROT, the buyer and the sub-buyer is sold also on an ROT. What we're saying is, does the sub-buyer get good title under the exception, buyer in possession exception, under section 25? The answer is no, because section 25 only applies where the buyer sells to his sub-buyer. Because of the ROT between the buyer and sub-buyer, there's no sale. It's just an agreement to sell. But if you look at section 9 of the Factors Act, which technically is what section 25 of the Sale of Goods Act adopted, section 9 does include an agreement to sell. So if you use section 9 of the Factors Act, sub-buyer does get good title. But what I'm saying is, under section 25 or section 9, it presupposes that the buyer is acting as if he were a mercantile agent. But in the Ramalpa cases, the buyer really is a mercantile agent. If he really is a mercantile agent, then it is the factors exception that applies. The exception is under section 21 sub 2, which is the same as section 2 of the Factors Act. Remember, there are 4 conditions before the factor can pass title. The first factor is goods are in possession of the mercantile agent in his capacity as mercantile agent, buy and sell capacity. He has possession of the goods at the time of sale. He has possession of the goods with consent of the owner. Fourthly, the transaction to the innocent third party is in the ordinary course of business. So if the factors exceptions are satisfied, the 4 conditions are satisfied, then the sub-buyer will get good title. But the factors exception only applies where the mercantile agent sells. There is no reference to agreement to sell. So you see, the factors exception does not help the sub-buyer in an ROT situation, because the agreement between the buyer and the sub-buyer, it is only an agreement to sell. It only becomes a sale when property passes. In other words, when the sub-buyer pays. So the sub-buyer will lose out. The original seller is still the owner. So the original seller can retake possession. The seller is still the owner. That's because the nemo dat exceptions do not apply to help the sub-buyer. Not section 25, buyer in possession, not section 9, buyer in possession, not section 21 sub 2, factors exception. In a way, it kind of flies in the face of post-Ramalpa case law. It is difficult to justify on legal principles because post-Ramalpa cases, all the cases after Ramalpa, what they say is as soon as goods are sold by the buyer to the sub-buyer, then as between the seller and the buyer, that ROT is cancelled and replaced by a charge over the manufactured goods or the proceeds of sale. The crucial point here is that when the buyer sells to a sub-buyer with an ROT, that agreement is an agreement to sell. So as between the ROT, as between the seller and the buyer, this ROT clause remains intact. That's why the original seller remains the owner. Of course, in a way, this is justice, isn't it? I mean, why should the seller lose out? Because the alternative would be either the buyer's receivers get the goods or the sub-buyer gets the goods. And neither of these people have paid. Let's look at mixed goods. This is often called the manufactured goods clause. Going back to the Romalpa case, now the Romalpa case had a contract clause. The second clause said ownership of mixed foil would transfer to the ownership of the finished product until the seller was paid. But this clause does not make sense. How can it mean the seller now owns the finished product? It can't be. The seller can only reserve title in goods if he has title in the first place. Example, I sell you a piano on conditional sale. I have a clause in the contract that says, I reserve title in your whole house. Well, that's ridiculous. It doesn't make legal sense at all. In Romalpa, the Court of Appeal said, that's because the buyers were bailees of the foil. But this is not a good argument. Bailment involves the idea that the bailee will re-deliver the very same goods to the bailor at some stage. I say, for instance, give me my piano back, which is fine, because I'm expecting the same piano to be returned to me. But in these types of commercial cases, the goods are used in the manufacturing process, so redelivery of the same goods is not possible. The aluminium foil is used to make something else. The transaction cannot be bailment. It's just a contract of sale, and the seller's claim to title over the new product or the proceeds of sale, that's a charge or a mortgage that requires registration. Now, the physical character of goods can change in one of two ways. The first way is where the manufacturing process converts goods into a new product without mixing them with other raw materials. The second type of mixed goods is where the manufacturing process converts goods into a new product by mixing it with other raw materials. In the first type, in other words, where the manufacturing process does not mix the original goods with other goods, there are conflicting views on this. Probably the answer is the goods are treated as unmixed goods. So an ROT is effective to retain title. We use a New Zealand case to support this proposition. Ponkagower against New Zealand Forest. Timber logs supplied in this case were turned into timber, then it was turned into bark, then it became chips, and then it became sawdust. The court said the ROT clause was effective. That's because the original timber logs were not mixed with other goods. The logs were just processed into another form. The court said it is a question of degree whether goods have been irrevocably incorporated into a new product. The court said the logs had not changed. They were just modified. Having said that, the situation is not that clear, because although the court in ICI against Agnew, which is another New Zealand case, Although the court in ICI said it followed the Ponkagowa case, it didn't. The seller, you see, supplied plastic pellets with an ROT clause. The pellets were made into plastic containers. No other raw materials were supplied. The court held that an ROT clause was not effective against the finished product. The seller argued, hey, the pellets had not been mixed with other goods. The containers were still plastic, chemically the same as the pellets supplied, just a different shape, that's all. But the court said no. The plastic containers had an obvious identity of their own. So the ROT clause was ineffective against the finished product. So it's not 100% clear whether goods which are not mixed with other raw materials but look different, whether that amounts to becoming mixed goods such that an ROT clause becomes ineffective. There's a conflict in cases. We said that the physical character of goods can change in one of two ways. The first is where the manufacturing process involved the original goods turning into a new product without mixing with other raw materials. We've just looked at that. It's not 100% clear, but whether an ROT clause extends to the modified product might depend on the degree the goods have been irrevocably modified. The second type of mixed goods is where the manufacturing process involves mixing the original goods with other raw materials. Well, the first thing to say is if the seller supplied all the raw materials to make the finished product, the seller supplied the foil, the glue, and all the other stuff, then maybe okay. Maybe the seller can transfer ownership to the finished product. But this is unlikely in practice, and there are no reported cases on this. So what we are looking at here is goods supplied by the seller have become incorporated with other raw materials to make the finished product. Well, the law on this is pretty clear. The ROT is ineffective, not effective, against the new product. Let's look at the cases. In Re Peachdart, the seller sold leather with an ROT clause. The buyer used the leather to make handbags. Court said the seller cannot reserve title in the handbags because the leather ceased to exist as separate goods when they were made into handbags. The only effect of the ROT clause was that the seller had a charge over the finished product. But because the charge was not registered under Section 859A, Section 859H says that the charge is void. The principle is quite clear. If mixed goods are involved, the ROT clause operates as a charge on mixed goods and the proceeds of sale. It needs to be registered, otherwise it is void. This is true whenever the manufacturing process means that the original goods have lost their identity. Examples include Re Bondworth. Wool was made into yarn, which was made into carpet. Sorry, the original identity has been lost. ROT is discharged. Borden against Scottish Timber. Resin turned into chipboard. But if the original goods can still be identified, the seller can retake goods. The leading case is Hendy Lennox against Graham Puttick. The buyer bought a diesel engine. The seller reserved title. The buyer used the engine as part of a huge generator, and the buyer went bust. The engine remain unchanged. And it was readily identifiable because there was a serial number there and it could be dismantled from the generator quite easily. The court said yes, the seller can retake his goods because the original engine was easily identifiable. Note that ROT cases are always very fact-specific. Just because goods remain identifiable, it does not mean that ROT clauses is effective. What is clear is that goods must remain identifiable to have a chance of the ROT clause being effective. Whether goods remain identifiable depends on the facts of each case. See the case of in the matter of CKE. The seller sold 217 tons of zinc ingots to the buyer. The buyer was in the business of galvanizing metal, in the business of melting metal. There was the usual ROT clause in the contract. Both the seller and the buyer went into liquidation. At the time the buyer went bust, the buyer had 265 tons of molten zinc. The seller argued, hey, it's still zinc, just melted. Melted zinc was not a new product. The buyer argued the ROT clause only applied to the original zinc ingots which lost their identity when they were added to the tank and mixed with other zinc. The court said ROT was effective. ROT clause applies not just to the original ingots because both the seller and buyer knew that the ingots would immediately be mixed with zinc in the tank. The court said there was no problem for the seller to share in the ownership of the molten zinc. CKE supplied 217 out of the 265 tons of zinc in the tank. So the court said CKE can therefore claim ownership of 217 divided by 265. Let's look at proceeds of sale. This is often called the proceeds clause. Now, in the Ramalpa case, the Court of Appeal said the seller was entitled to the proceeds of sale of the finished product. That's why the seller got back £35,000 in a separate bank account, because the contract term was that the buyer acts as fiduciary. Buyer was reselling the goods as agent for the seller. But this cannot be right. In agency law, when the principal authorizes his agent to sell goods, it is the principal's goods that the agent is selling. That's why when the agent sells, whatever the third party pays for it belongs to the principal, all of it. And the agent just gets remuneration in accordance with the agency contract. But this is not what happens in a normal contract between a seller and a buyer. The buyer is not an agent, not even with an ROT clause. It's just the relationship. It's just a normal business buyer and business seller. The business buyer has no duty to account for the proceeds in any particular way. The buyer is not an agent. The normal situation in a seller and a buyer situation is that the buyer is reselling to his sub-buyer on his own account. Pfeiffer against Arbuthnot. In Pfeiffer, there was an ROT clause in the proceeds of sale up to the amount the buyer owed the seller. The court said the seller was not entitled to the proceeds of sale. The ROT clause amounted to no more than a charge. And as we've said, if that charge is not registered under section 859A, 859H says that the charge is void. If the seller wants to get his hands on the proceeds of sale, not only must the seller reserve title, but somehow show that there really is a fiduciary relationship. A fiduciary relationship will not arise in a sales contract unless there is specific agreement between the parties creating one. It's not enough just to stick an express term that buyer is fiduciary. You've got to look much more closely at the substance of the relationship. Give you an example. If there is a credit period between the seller and buyer, if the credit period is, let's say, 90 days, the inference is that within that credit period, the buyer is free to use the sale proceeds in any way he wants. The buyer does not have to pay the seller to the end of the credit period. That already defeats the seller's claim to those proceeds, even if the monies were placed in a separate account. See, the Court of Appeal in Ramalpa said that's the decision, point number 3 at the bottom. The Court of Appeal said that the buyer acted as fiduciaries and the seller can trace into the proceeds of sale. Well, the right to trace, of course, is an established feature of trust law. Now, you will know from your trust lectures the famous statements made by Sir George Jessel, Master of the Rolls, in Re Howlett's estate. But there needs to be something more than just the mere relationship of debtor and creditor for the remedy to be available. Whilst the essence of an ROT clause is that the seller retains at least an equitable interest in goods, it is more difficult to show that the buyer is a person who holds property in a fiduciary capacity. If under the original agreement, the buyer has a credit period and the buyer is free to deal with goods or proceeds of sale as he pleases, no fiduciary relationship exists between the seller and the buyer. What is clear is that the courts are unlikely to hold that the fiduciary relationship exists until certain very special features exist, unlikely to happen in the commercial world. The conclusion is this. Essentially, a business seller will attempt 4 different types of ROT clause. The first one is the simple clause. Seller retains title to unmixed goods in the buyer's possession. Okay, this does not create a charge because title remains with the seller. The buyer has no title. The buyer cannot create a charge over something the buyer does not own. So the title is with the seller. Only the seller can create a charge over it, not the buyer. The seller will also attempt an all monies clause. The seller retains title to goods until all debts owed by the buyer to the seller are extinguished. Okay, so as far as simple and all monies clauses are concerned, there are no problems at all about reserving title to the original goods because Section 19 is very clear. Mind you, having said that, even a simple clause is not always effective. We've seen the difficulties. The buyer has an express or implied right to resell, and we've seen the Nemodat problems. 4-point garages, we saw Fairfax against Capital Bank. So the seller will, that's the case. The seller will also, of course, attempt a manufactured goods clause. The seller retains title to goods even after undergoing the manufacturing process. The 4th type of clause is the proceeds clause. The seller is entitled to proceeds of sale of goods to the third party. Well, as far as the manufactured goods and the proceeds clauses are concerned, if the seller wants to extend his right to mixed goods or proceeds of sale, there is a problem. The charge needs to be registered. That's all there is to it. Now, the purpose of ROT clause is clear. The seller wants preferential treatment if the buyer goes bust. Section 19 itself is no problem for unmixed goods. But if mixed or proceeds of sale is concerned, the seller must register his interest. Of course, one fundamental principle of commercial law is freedom of contract. So parties should be allowed to agree whatever they want to agree, party autonomy. But ROT affects third parties. By inserting an ROT clause, the seller is essentially jumping the queue if the buyer goes bust. The whole point about requiring registration is, if the seller is to have priority over other creditors if the buyer goes bust, that priority should be publicized by some form of registration so other people know about it. I mean, if I'm a potential supplier and I go to the buyer's factory and I see, wow, loads of goods. Well, I think these are the buyer's goods and I think the buyer is creditworthy. Well, it's not fair on me, the third party. That's why, you see, there are statutes that require registration of transactions where a person grants a mortgage or a charge over property. If it's an individual person, you're looking at the Bills of Sale Acts. If the buyer is a company, then the Companies Act 2006 applies. If the particulars of charge are not delivered to company's house within certain time limits, the charge is void against the creditors and liquidators of the company. When a company goes bust, the receiver usually challenges the ROT clause based on two arguments. First, the ROT clause is not incorporated, so the buyer is not bound by it. Remember, we've looked at common law incorporation rules, previous course of dealings, that sort of stuff. The second usual challenge is that the ROT clause is nothing more than a charge, so it is void because it has not been registered. Now, you might be wondering why the seller just doesn't register the charges. Well, the problem is, you see, in the UK, it's just a pain to register charges. There are time limits and there are forms to fill. So if the seller is a small business, the admin involved sometimes outweighs the advantages. The small business seller simply takes a risk. He hopes the buyer will pay his invoice. Large companies with high value sales, they are likely to have an entire department doing nothing but ensuring that the charges are registered. But it's difficult for small businesses to cope with the admin involved. All right, well, that's a good place for us to take a 10-minute break. When we come back, we'll finish ROT. All right, we'll take a 10-minute break. Okay, we're still looking at ROT clauses. Now, in order to have any chance of an effective ROT clauses, there are 7 steps that the seller can take. First of all, you must incorporate the ROT clause, including an all liabilities clause. Second, the seller needs to include a term that the proceeds of sale is to be kept in a separate account and not in a normal trading account. Third, the buyer cannot use the proceeds of sale as he wishes. Fourth, store the goods separately. 5, express acknowledgement of the fiduciary relationship and clear wording in the contract specifying the nature of that fiduciary relationship. 6, buyer sells as agents for the seller. 7. Make it clear that the intention of the parties is that the seller has the right to the excess of the proceeds of sale after payment of the price for the goods. In other words, the seller is under no liability to account to the buyer for any surplus over and above the price of the goods. To be frank, there's possibly an eighth. The seller authorizes the buyer to resell, but on terms that when the buyer sells to the sub-buyer, the buyer includes an ROT clause into that contract with the sub-buyer. Because then, you see, the Nemodal exceptions don't apply. Not Section 25, not Section 9, not Section 21 sub 2. But of course, this only works if goods remain identifiable. I sell you a car, I sell you a piano. Not if leather is used to make handbags. Forget it, that won't ever apply. In fact, there's a Court of Appeal case which kind of throws ROT up in the air. Caterpillar against Holt. Let me tell you about this case. Sellers sold generators to the buyer under an ROT clause. The clause contained exactly those 7 steps we've just talked about. The buyer resold the generators to a sub-buyer in Nigeria. The buyer was not bust. It's just that the buyer didn't pay. The seller sued the buyer for price under Section 49 of the Sale of Goods Act. This was worth $12.6 million US. Now, points 5, 6, and 7 on the screen, those 3 steps were expressly incorporated as terms under the contract. Now, there were 2 questions for the court. The first one was an ROT question. Did property pass to the buyer when the buyer sold to the sub-buyer? Now, this was relevant, you see, to the second question on Section 49. The second question was this: is Section 49 the only way the seller can sue for price? Or is Section 49 just one way? Now, we haven't done it yet, but we will. Section 49 says the seller can sue for price only if 1. Property passed to the buyer. 2. Buyer refuses to pay. We will look at this in more detail later. But question 1 in this Caterpillar case was this: did property pass to the buyer when the buyer sold to the sub-buyer? The Court of Appeal decision was a 2-to-1 majority. The ROT clause was effective. So the seller retained title till he got paid. When the buyer resold as the seller's fiduciary agent, not as principal. This means that title passed directly from the seller to the sub-buyer. In other words, it was normal agency. We already said an agent never owns his principal's property. The contract is between the principal and the third party. This was emphasized, the court said, by Clause 7, because Clause 7 of the 7 steps, which says that the buyer was to account to the seller for the entire proceeds of sale, not just the amount owed to the seller. This meant, the court said, that the buyer was acting as fiduciary agent. Longmore, who was the dissenting judge, he agreed with the first instant judgment. He thought title passed to the buyer immediately before the sale to the sub-buyer. The second question was this: is Section 49 the only way seller can sue for price? Or is Section 49 just one way? The Court of Appeal was unanimous on this point. They said, yes, Section 49 is the only way seller can sue for price. In other words, only if property has passed to the buyer and the buyer refuses to pay. Now, we've seen the case of res cogitans. We know this case. Note that the Supreme Court in res cogitans said that it is unlikely that Caterpillar would be followed on this point. On the facts of the case, the seller lost. Seller was suing the buyer for price. This was not possible because property did not pass to the buyer. Longmore, of course, the dissenting judge, he said, hey, the seller could have sued for Section 50, damages for non-acceptance. But this is not satisfactory because Section 50, subject to remoteness rule, subject to mitigation rules, this is not the same as price. Anyway, it's a bit crazy to sue for Section 50 non-acceptance damages when the buyer has obviously accepted the goods. Buyer has sold to someone else for money, for heaven's sakes. But because Section 49 was the seller's only claim, the seller lost. As Longmore said, ROT clauses has dangers as well as benefits. The other big issue, of course, is the court said title passed direct to the sub-buyer. Direct to the sub-buyer. So title here directly to the sub-buyer. If this was a real principal and agent situation, it would mean the contract is between the principal and the third party. In other words, the real contract will be between the seller and the sub-buyer. Huh? I mean, does that mean that the sub-buyer would sue the seller direct if there was, let's say, a breach of Section 14, quality and fitness? This is not at all clear. In Caterpillar, leave to appeal to the Supreme Court was granted, but the appeal was settled just before the Supreme Court hearing date. But this leaves us in a very unclear position. Because of Caterpillar, maybe we need to rethink the 7 steps. Maybe we need to revise steps 5, 6, and 7. Maybe we should change them to when the buyer resells, title notionally passes from the seller to the buyer immediately before the goods are resold. This was Longmore's suggestion. 6. When the buyer resells, the buyer resells as principal, not agent. 7. Limit the fiduciary relationship to the outstanding price for the goods and not the entire proceeds of sale. Maybe that is a better solution to ensure that the ROT clause is effective. Now, what happens 1 week after the Caterpillar against Holt case? Well, another generator case comes up. Fadala against Polak. We already saw this case in Nemodat. Let me remind you. Seller sold second-hand generators to buyer number 1. Buyer number 1 paid in full. Buyer number 1 had no storage, so the seller agreed to store them until the buyer found a sub-buyer. Buyer 1 physically watched the generators being disconnected and transported to the seller's warehouse for storage. Shortly after, buyer 2 wanted to buy generators. The seller sold buyer number 1's generators to buyer number 2. Buyer number 2 had no idea the seller did not own them. Buyer number 2 paid in full. Seller asked to buy back the generators from buyer number 1. Buyer number 1 agreed, but they inserted an ROT clause. In other words, buyer 1 reserved title until seller paid them in full. The seller went bust without paying buyer number 1. So buyer number 2 is now suing buyer number 1. Remember, both B1 and B2 are innocent. One of them was going to suffer a huge loss. The court said buyer number 2 loses out. The ROT clause between buyer 1 and the seller, that was effective. So title remained with buyer number 1. Now, these two generator cases, Caterpillar and Fadala, they make for a pretty good exam question, don't they? I mean, instead of giving you a straightforward ROT or no doubt essay question, we could combine ROT and no doubt. We dealt with the no doubt exceptions when we looked at Fadala. All right. So I'll just quickly revise that with you here. Because of this effective ROT clause, remember that means that title was with buyer 1. So the seller did not have the right to sell. The seller cannot pass title because of no doubt, the general rule. You can't give what you haven't got. So buyer number 2 argued the no doubt exceptions. Buyer number 2 argued section 21 sub 1 estoppel. Court said no. Buyer number 1 did nothing intentional nor were they negligent to represent the seller had the right to sell. Allowing seller possession in itself is not enough. Buyer number 2 then argued section 21 sub 2 factors exception. Court said no. The seller was not a mercantile agent. The seller was not in possession of the generators in his buy and sell capacity. He was in possession as a storage person only. Buyer number 2 then argued section 24, second sale by seller in possession. Court said no. The seller did not remain in continuous physical possession because buyer 1 attended and watched the generators being dismantled and transferred to the warehouse. Buyer number 1 had taken possession at that time. So that's why the seller was not in continuous physical possession. Buyer number 2 then argued section 25 buyer in possession. Court said no. The seller was not a buyer in possession at the time the seller sold to buyer number 2 because seller only agreed to buy back the generators from buyer 1 after he had already sold them to buyer number 2. So seller was only a buyer in possession after the sale to buyer 2. So buyer number 2 lost all his arguments. None of the no doubt exceptions applied. Buyer number 1 remained the owner. Now, as I say, these two generator cases make for a pretty good problem question. Anyway, let's go back to res cogitans. Now, we've seen this case twice already. If you remember, the seller supplied bunkers to the ship owner. The contract terms included an ROT clause, an express term that the buyer can use the bunkers from delivery, and the ship owner had 60 days credit. The seller bought bunkers from the physical suppliers who delivered direct to the ship owners. The contract between the physical supplier and the seller also had an ROT clause. The seller went bust. No one had paid anything. There were 3 questions for the Supreme Court. The Supreme Court were unanimous in their decision. Lord Muntz delivered judgment. Question 1. Was the contract a contract of sale within the meaning of the 1979 Act? Court said no. Because of the contract terms, ROT, express term buyer can consume, and credit period, court said the parties knew the bunkers would be used immediately. In other words, the goods would be consumed before payment. If there were no goods at the time of payment, then there is no property in goods to pass. If there is no link between the transfer of property and money, then it is not a contract of sale. Section 2 sub 1 of the Sale of Goods Act is not satisfied. Now, we know there are criticisms. We discussed them already. Question 2. If it was a contract of sale, is the seller in breach of section 12? Court said Section 12 does not apply because the Sale of Goods Act does not apply. But Mance went on to say that the seller does not need to have title anyway. Seller only needs the right to sell. The seller does not need to be owner to have the right to sell. Now, finally, let's look at question 3. If it was a contract of sale, is Section 49 the only way the seller can sue for price? The ship owners, you see, were arguing Caterpillar. Section 49 says the seller can only sue for price if property has passed and the buyer refuses to pay. The physical supplier retained title under the ROT clause, this clause here. He retained title under the ROT clause. So the seller had no property. So the seller, this guy here, went bust. The seller cannot pass property to the buyer. So the ship owner argued, if property hasn't passed to them, the seller cannot sue. So the ship owner argued that if property hadn't passed to the seller cannot sue them under Section 49. The Supreme Court said, on the facts of the case, it was not a contract of sale anyway. But even if the 1979 Act did apply, the Supreme Court said Section 49 is not a complete code of situations when price is recoverable. Now, the Supreme Court said if the 1979 Act did apply, they would overrule Caterpillar on this point. Remember, the Supreme Court here was saying this obiter. The House of Lords did not have to decide on the point. On the facts, it was not a Sale of Goods Act contract, but the Supreme Court said the ship owner must pay. The ship owner got what they wanted, the right to consume the bunkers. This was a straightforward contract debt claim. There is no need for property to pass. Let's look at the impact of res cogitans. There are two problems with res cogitans. There's a sale of goods problem and there's ROT problem. Let's look at the sale of goods problem. Remember, the facts of res cogitans was that the contract terms between the seller and the ship owner had an ROT clause, express term buyer can consume, credit period. The Supreme Court said this was not a sale of goods contract. This seems to suggest if these three features exist, the Sale of Goods Act does not apply. In fact, even if there wasn't a term allowing the buyer to consume or to use the goods, the courts will imply such a term anyway between businesses. We saw the two ROT cases, 4-point garages, and we saw Fairfax. The courts will imply a term in commercial contracts that the business buyer had the right to use or resell the goods. Otherwise, as we said, how is he going to pay the seller? The Supreme Court said the contract between the seller and the ship owner was not a sale of goods contract. This means the buyer has no Sale of Goods Act protection. It's a problem like software. Because software is not goods, there is no Sale of Goods Act protection, no Section 14 satisfactory quality and fitness for purpose. Sure, we hope the courts will imply the terms under the common law, and we know the two tests, business efficacy test, officious bystander test. Of course, courts can also imply terms into the contract because of customs of the trade or previous course of dealing, but all of this creates uncertainty. If there's a chance that the contract has the features in the res cogitans case, it's best to expressly incorporate the terms implied under the Sale of Goods Act. The second problem with res cogitans, and this is the real problem actually, it's the ROT problem. You see, commercial sellers usually sell goods to the buyer with an ROT clause. The buyer sells the goods to a sub-buyer or uses the goods in a manufacturing process. In either of these situations, the buyer has not yet paid. Does this mean none of these contracts are sale of goods contracts? We already said ROT clauses are only ever useful if the goods remain identifiable. When goods are used in a manufacturing process, the goods are no longer identifiable. We know that the seller's title ceases to exist. The seller's interest is just a charge over the new product. It's like leather turning into handbags. If the original goods are no longer identifiable, the effect surely is the same as if the goods have been consumed, like the bunkers. The ship owners consumed the bunkers as soon as they took delivery. Is the House of Lords in res cogitans saying that the contract between our normal seller and buyer is not a contract for the sale of goods because the original goods no longer exist? The leather has been cut up and made into handbags because goods no longer exist, so the buyer is not paying for property? Well, we've always thought these types of supply contracts were sale of goods contracts, so the Sale of Goods Act applies. But if Lord Mance is right, the Sale of Goods Act won't apply to these sui generis contracts, and the buyer and seller don't get the protection of the Sale of Goods Act provisions. In other words, a contract which contains an ROT clause is not a sale of goods contract, but a sui generis contract. This is very worrying decision. Res cogitans is disturbing established law. We don't like it. So no one is sure what to do. Maybe we should forget ROT clauses. In res cogitans, if there was no ROT, title would have passed earlier. It would mean maybe Section 2 sub 1 Sale of Goods Act would be satisfied after all. So yes, it is a sale of goods contract. Yes, the buyer would get sale of goods protection. If the seller wants to retain security before payment, maybe he should consider other methods. Maybe payment by LC, letter of credit. That will provide security if the buyer goes bust. Or what about the physical supplier? Could they sue the ship owners in conversion? In other words, the ship owner has wrongfully interfered with the physical supplier's goods. The physical supplier were the bunker owners after all, when the ship owners consumed the bunkers. Obiter, the Supreme Court said no. The physical supplier expressly or impliedly consented to the use of the bunkers by the ship owners. The physical supplier knew that the seller was not the end user. He was just an intermediary in a chain of contracts. In fact, the physical supplier delivered the bunkers direct to the ship owners. Well, this is okay in English law, but what if English law does not apply? It means that the buyer potentially is liable to pay for the same fuel twice. Pay the seller as a contract debt, pay the physical suppliers who will claim the ROT. Chances are in future, suppliers and seller will demand cash upfront unless we can sort this out. And this is not good for business. In fact, there are lots and lots of other issues not dealt with in res cogitans. There's loads of litigation around the world right now. OW Bunker was the world's largest supplier of bunkers. It collapsed in 2014, 10 years ago. But there are lots of cases involving disputes to do with unjust enrichment between competing claimants. It will be years more when all of these claims have been dealt with. Interestingly enough, actually, as far as the second question is concerned, in other words, is the seller in breach of Section 12 anyway? The seller argued there was no breach of Section 12 because, they said, they were buyers in possession. Section 25. So they could pass title to the ship owners anyway under the Nemodal exception. The court said no. Why? Because this is a very situation of ROT plus ROT. Title did not pass to the sub-buyer. In other words, property did not pass to the ship owner. This was the point we made earlier. When there is an ROT plus ROT, none of the Nemodal exceptions apply. Not Section 25, buy and possession, not Section 9, buy and possession, not Section 21, sub 2, factors exception. All right, let's look at a question. This question is whatever page it is in your handout. Let's read it out loud together. Let's look at an ROT question. All right, I'm going to read it out loud once. Sorry, let me just go to this page. This is the question we're going to look at now. Okay. Alpha Limited were furniture makers. Wood was supplied to them by, oh, sorry, just give me a second. Okay. Wood was supplied to them by Beta Limited under a contract which contained the following clause. All wood supplied by Beta Limited remains the property of Beta until it has been paid for. Any product in which the wood is subsequently incorporated shall remain the property of Beta until all wood supplied has been paid for in full. Should the wood be sold by the customer before it has been paid for, the customer must pay all the proceeds of sale into a separate bank account and then account to Beta within 30 days for the whole of the proceeds of sale, provided that sum does not exceed the amount of the debt owed by the customer to Beta. Alpha is now in liquidation, and it owes Beta £50,000 in respect of wood supplied by Beta. All the wood supplied has been used in the manufacture of furniture. Wood to the value of £5,000 has been cut and treated, but has not otherwise been used by Alpha. Most of the wood had been used to make tables. 50 tables worth £35,000 have been found in Alpha's factory. A bank account opened by Alpha, called its supplier's account, has £15,000 deposited in it. The money appears to be the proceeds of the sale of some furniture. Kane Furniture plc claims that it is entitled to 40 of the tables in the factory on the ground that it has paid a 50% deposit for each table. Kane has produced an invoice which demonstrates that it has paid the deposits for the tables. 20 of the tables have labels on them which state that they are to be delivered to Kane, but there is no other indication of which tables were to be delivered to Kane. Advised Beta Limited and Kane Furniture plc. All right, I'll give you literally a minute to reread, 1 minute to reread, and then we'll just do it. 1 minute to reread. Okay. Well, I hope you've had a chance to reread that. Now, we have two clients, Beta and K. Now, Alpha is in liquidation, owing Beta, our client, £50,000 for wood supplied. Beta wants to know if the ROT clause is effective to help recover the wood they supplied. Kane has paid for some tables. Kane wants to know if they can take some of the tables which are in Alpha's factory. Well, the rough work is dead simple. Actually, I've kind of done it for you. Rough work is amazing with ROT questions. It's almost always the same. It doesn't really matter what the question is because it's always about unmixed goods, mixed goods, and proceeds of sale. So rough work doesn't change at all. So beta is very straightforward. It's pure ROT. What's Kane about? What's the rough work for Kane? What's Kane about? I mean, Kane says he's paid a 50% deposit. So that's why he says he's entitled to 40 of the tables in the factory. Why does he say that? I mean, is Kane saying he's got property in those tables? Maybe we need to discuss when property passes between a seller and a buyer. When does property pass to Kane? He's the buyer. What's the first thing we need to establish? You tell me. Because our client is claiming that we have property in those tables. That's why that's why we own them, and that's why we can take them. Well, we then need to discuss when does property pass to our client, Kane? He's the buyer. What's the first thing we need to establish? Thank you very much indeed. Yes, correct. The first thing we need to establish is what type of goods we've got. Because you know the rules are very different. And you've correctly identified, thank you, that we're looking at unascertained goods. So I'm asking you, when does property pass in unascertained goods? You tell me. When does property pass in unascertained goods? What is the starting point? What's the starting point? Always with unascertained goods. When does property pass? Thank you. The answer is section 16 is always the starting point. Have the goods ever become ascertained? Well, we're not sure because the tables have been set aside with Kane's name on it. So maybe, yes, they've become ascertained. But then we know section 18, rule 5.1. Rule 5.1 requires that goods of contract description in a deliverable state must be unconditionally appropriated to the contract. Now, these tables might have been set aside, but that does not mean they have been unconditionally appropriated. That's the Carlos Fiederspiel against Charles Twigg case. So if the goods are not yet unconditionally appropriated, does that mean that property cannot pass to Kane? They are unascertained goods. So section 16, what are you meant to discuss? What are you meant to discuss? Because what we're saying is they are unascertained goods, section 16. So what are you meant to discuss? Thank you very much indeed. Yes, correct. We are told that Kane has paid a deposit. One big exception to section 16 is 20 big A. So this bit about Kane has nothing to do with ROT, but it has everything to do with passing of property. Now, let's just answer the question in a bit more detail. We won't bother to do it in 100% full because we've only just studied this topic and you've not really had a chance to write up your notes and think about it. But let's start off with beta. Alpha is in liquidation, owing beta £50,000 for wood supplied. Beta wants to know if the ROT clause is effective to help them recover. The leading case, of course, is Ramalpa itself, so you must go through the facts of the case. I won't bother to repeat it here because we've just done it. The Court of Appeal said the £50,000 worth of unmixed foil still belonged to the seller because the seller reserved title. The seller was also entitled to the £35,000 kept in the separate bank account because the buyer acted as agents. Always say the Ramalpa is an unsatisfactory decision. So subsequent cases have not unsurprisingly, restricted the authority of the case. So we will now see how the rules affect Beta's situation. Well, the first bit is to do with wood valued at £5,000, which was cut and treated. Well, we will call this unmixed goods. Your answer always involves these three big paragraphs. It is clear from Ramalpa that where the seller puts a term in the contract, reserving title till he gets paid, this is effective. I said, always say that this has been confirmed by Cuff Mill against Martin. Now, the reason why I always say confirmed by it, because Ramalpa is such a controversial decision, that this bit is not controversial. This bit we agree with. Now, in Ramalpa, of course, the buyer had £50,000 worth of unmixed foil. So the Court of Appeal said the seller can recover the unmixed foil. So in our question, we're told the wood has been cut and treated, but it's not mixed with other goods yet to make furniture. So yes, we think Beta can recover the unmixed wood because the goods were identifiable. Beta remains the owner. It does not create a charge. The buyer cannot create a charge if he is not the owner. The second thing we are told in this question is that wood was used to make tables, and these were worth £35,000. We're talking now about mixed goods. The first thing to note is that there does not appear to be an all monies or liabilities clause like Armour against Thyssen. It's also not clear from the clause whether Beta authorized Alpha to resell the goods. Whatever, even if there is no express term permitting it, the courts will imply that Alpha has the right to resell. We have two cases on this point, 4 Point Garage and we have Fairfax against Capital Bank. Go through the facts. Now, actually, Fairfax against Capital Bank is quite complicated about the printing machine from China. There was finance company number 1, finance company number 2. I think the facts are too complex to write out. So I suggest give the facts of 4 Point Garage against Carter, which is the simple case about commercial car dealers, and just say that the principle was confirmed by Fairfax against Capital Bank. I won't bother to remind you because we've only just covered ROT. We did it a moment ago. Now, Beta wants to claim the tables. Well, I'm afraid this is going to be ineffective because Beta can only reserve title in goods in which they had title to in the first place. Beta's claim to title over the tables, which is a new product or indeed proceeds, it's a charge or a mortgage requiring registration. We said that the physical character of goods can change in one of two ways. The first way is where the manufacturing process converts the goods into a new product without mixing them with other raw materials. The second type of mixed goods is where the manufacturing process uses new other raw materials to turn it into a new product, mixing it with other raw materials. In this question, the wood has been made into tables. Even if no other raw materials are involved, it's not always clear whether the ROT clause would be effective in the finished tables. There's a conflict in cases. We saw the two New Zealand cases, Honkogawa, where the timber logs turned into sawdust. Court said ROT was effective. It was still the same goods, seller can retake. In ICI against Agnew, Plastic pellets turned into plastic containers. Court said ROT not effective because the containers had their own identity. They were not the same goods. I think even if no other raw materials were used to make the tables, I think it is unlikely the courts will say that the tables were the same goods. I mean, the degree of change from wood to a piece of furniture is quite a lot. Maybe we should query, actually, whether our client Beta supplied all the materials to make the tables, not just the wood. Did Beta supply the glue, the nuts, the bolts, and the other stuff? If Beta did, then maybe okay. Maybe Beta can transfer the ownership to the finished product. But unlikely. Presumably, Beta did not supply all the substances to make the tables. It's pretty unlikely. And there are no reported cases on this anyway. More likely, the tables were made out of mixing the wood which our client Beta supplied with raw materials from other suppliers. If that's the case, then the principle seems to be clear. The ROT clause operates as a charge on the mixed goods and proceeds of sale. This needs to be registered with Companies House, otherwise the charge would be void. This is always true whenever the manufacturing process means that the original goods have lost their identity. Then go through the cases, re-peached up leather into handbags, re-Bondworth wool, yarn, carpet, Borden against Scottish timber, resin into chipboard. But always say that if the original goods are still identifiable, Beta might be able to retake those goods. In other words, if the wood is readily identifiable. Go through the case. Hendy, Lennox against Graham Puttick. That's the case about the diesel engine. The point you want to stress is that ROT cases are very fact specific. What is clear is that goods must remain identifiable to have a chance of the ROT clause being effective. And this depends on the facts of each case. Go through the facts of in the matter of CKE. That's the zinc ingots case. Query, actually. Query whether it is possible for Beta to dismantle the tables. Because if you can just dismantle the tables easily, then maybe Beta can reclaim the wood. It's pretty unlikely though. So if it is not possible, I'm afraid Beta cannot reserve title in tables because the wood has ceased to exist as separate goods. So I'm afraid the £35,000 worth of tables in Alpha's factory does not help Beta recover the debt. This is because once the wood is mixed with other goods, the ROT operates as a charge on the mixed goods, and the charge needs to be registered with Companies House within 21 days. So unfortunately, if it was not registered, Beta will be an unsecured creditor for the balance. Now, Beta also wants to claim the £15,000 in the supplier's bank account. Well, this is a claim for proceeds of sale. Now, we know that in Ramalpa, there was a separate bank account with £35,000 in it. That was the proceeds of sales of finished products sold to suppliers. And the Court of Appeal said the seller was entitled to recover the £35,000 in the separate account. Go through and explain that at first instance, the judge said no registrable charge arose, but this point was not even discussed in the Court of Appeal, which is why we say Ramalpa is not a satisfactory decision. Because as it stands, what the Court of Appeal is saying is all the money received by the buyer from reselling the goods, all of it is held on trust for the seller. Explain all of this to Beta. It is unlikely that parties intended this to be the situation, but effectively, this is the outcome of the Court of Appeal decision. All Alpha Beta wants to do is to protect itself in case customers like Alpha goes bust. Beta only wants enough of the proceeds to pay off what Alpha owes them. This arrangement is a mortgage or a charge, and it needs registration under the Companies Act. Explain. There's been no other case since Ramalpa that the seller has managed to trace into the proceeds of sale. Now, even if beta authorizes alpha to resell, the principle is that alpha resells on his own account. So if that's the case, then beta is not entitled to the proceeds of the subsale. The authority for that is Pfeiffer against Arbuthnot. Now, it is not clear from beta's clause anyway whether alpha would sell as beta's agent, and there's no mention of a fiduciary relationship. It sounds as though beta's claim for the supplier's account will be unsuccessful if beta did not register the charge. So in conclusion, beta can recover £5,000 worth of wood, which has been cut and treated but not otherwise changed. Beta might be able to claim tables worth £35,000, but only if they are easily dismantleable. Otherwise, beta's interest is void if the charge was not registered. Beta cannot recover £15,000 proceeds of sale unless that charge was registered. I'm just doing this very briefly because obviously we've got all the notes in your main lectures, all right? Now, as far as Cain is concerned, well, that's a completely different thing altogether. Cain's right as a buyer depends on whether property has passed to Cain. We decided that the tables Cain agreed to buy were unascertained goods because the definition of specific goods under Section 61 is not satisfied. Section 16 says property in unascertained goods cannot pass until and unless the goods have become ascertained. It's not clear if the tables were ever ascertained. Even if they have been ascertained, Section 17 says it depends on the intention of the parties as to when property is to pass. It's not clear here. Now, if we applied Section 18, Rule 5.1, goods of contract description in a deliverable state must be unconditionally appropriated with the seller or buyer's assent. This is where the difficulty is, isn't it? Even if putting Cain's name on 20 tables amounts to ascertainment, goods are definitely not unconditionally appropriated. Go through Carlos Federspiel against Charles Twig. I'm not going to remind you of this case because we did it in lecture number 1. The court held that property had not passed to the buyer because it was an FOB contract anyway. That showed that the intention was that property and risk wouldn't pass until the bicycles were on board the ship. And the court said, when goods are merely set aside, goods are not yet unconditionally appropriated to the contract. It's just like our question. The tables have merely been put aside because unconditional appropriation, if you remember, is the irrevocable identification of goods. Irrevocable means the seller cannot change his mind. So just because 20 tables were set aside with Cain's name on it, this does not itself amount to unconditional appropriation. So no property passes to Cain under 18 Rule 5.1. Those tables still belong to Alpha. Now, I suppose we should mention the important case of Pignataro against Gilroy. This was the case about 15 bags of rice, which were set aside. In other words, they were appropriated, and the seller gave the buyer a delivery note and told when he could collect. The bags were stolen before the buyer collected it. So now, what the court said here was the seller's appropriation of the bags without objection from the buyer within a reasonable time, that amounted to assent. So title in those bags were transferred to the buyer, and they belonged to the buyer at the time the goods were stolen. Here, the reason why we want to mention Pignataro is even if Cain was told 20 tables were set aside for him, we can distinguish this situation, with Pignataro because we're not told anything about a delivery note. We're not told anything. So Cain did not have a delivery note. So I think property remains with Alpha. So Rule 5.1 won't apply to help Cain. But the big thing is we're told that Kane paid 50% deposit for 40 tables. Section 20 big A was inserted as an amendment to give buyers like Kane, who have paid for goods, some measure of protection if the seller becomes insolvent. Remember, there are 3 conditions that need to be satisfied before 20 big A applies. Must be a specified quantity. This seems to be satisfied, 40 tables. Identified bulk source. Go through the definition under section 61. Yes, this is also satisfied because all the tables are all exactly the same, or all identical. Third thing is the buyer must have paid for some or all of the goods. We're told Kane paid 50% for the 40 tables he ordered. This is the equivalent of fully paying for 20 tables. Kane probably is owner in common of 20 out of the 50 tables sitting in Alpha's factory. In other words, 40%. Kane is therefore entitled to 20 tables. In fact, we are told that 20 tables have labels with Kane's name already attached. So, bang, that's it. Of course, I've covered it fairly briefly, but we've done all of this thing on transfer of property in lecture 1, and ROT, we literally covered it today. So obviously you've got the full essay ready anyway. Now, so just note that ROT can be combined with transfer of property. We also said ROT and Nemo-DAC combination is also possible because we looked at the 2 generator cases. All right. That's a good place to end today's lecture. Tomorrow is the last lecture, and we'll start off with seller's remedies. All right, so good night, and I'll see you tomorrow.